Lights, camera. Action. Okay, let's get started. This is actually lecture 4. I know I promised project management, but I had a lot of people who said, well, I want to save for project management for next week. So I'm going to do it next week. Plus, I like to talk about the legal aspect of business software engineering today. So that's going to be our topic for today. And this is lecture 4. If you want to download the slide set and look at it, make sure to sign the roster that's going around the room. And make sure to keep the volume down in the back, because I don't have a microphone yet. And I know it's really hard to hear me back there, especially when I start getting tired. So I'm hopefully not going to get tired. I'm hopefully going to leave the volume up as high as I can get it to go. So, all right, so this is the nature of software engineering 2, is to talk about all the different subtopics. One of them that's of really good importance is the legal aspect in terms of how it applies towards developing software. And in the legal environment, what we're looking at is the business of developing software. So I talked about the business aspects last week, which is why I kind of like to follow with this lecture, because it gets into the legal aspect of it, a slightly different angle. And what we're looking at is being aware of the framework, the environment for which the software is going to be distributed in, the legal rights that you have when you write the software. There are a couple of different subtopics associated with this that I want to talk about, like the idea of using other people's source code, what happens when you write your own program, who owns it, you're working for a company, you're doing it solo, what happens when you let somebody use the software. So those are kind of the topics that I'm going to cover today in terms of the legal framework. And every software engineer kind of needs to be aware of it, actually, from a certain point of view. And also because you're a part of it. And as the blue little quote up there, software is developed in a complex legal and economic framework. It's a little bit more complicated than selling a product, like something that you would build. Because software, obviously, it's supported by an operating system. It's running on hardware. It's not necessarily sitting on an island of its own. And then what happens? Let's say, for example, you write a program, somebody installs it on their computer, and then their computer crashes. Are you responsible for every user out there? And there's more people that use software, and there's more software interaction with other programs and utilities than there is with other products. As an example, a mouse, mouse is a mouse. If it breaks, it's not going to hurt anything else, hopefully. And it's using drivers and things that are associated with the operating system, but who owns the drivers and who's responsible for making the drivers? And how do we know it works and stuff like that, which is kind of complex, actually, when you think about it. So every software engineer probably should be aware of it. But you also need to, basically, it's not a bad idea if you're going to go into software engineering as a sole proprietor, as a business owner, to be or have access to an attorney or a lawyer to actually get certain things written up officially. Because what you're going to find out is you're going to need software license agreements and a bunch of legal stuff that's associated with your distribution. So you need a lawyer for anything other than the basic legal issues or concepts that you might run into. So some of the topics that pertain to software engineering would be necessarily the distribution, international, federal, state, the jurisdiction for which you're distributing your software in, which is a little different, especially if you cross international borders. There's issues. You see them with hardware, but you also see them with software and printed duplicated disks, CDs, and stuff like that. If you've ever tried to export or import that, it's a huge issue. And there's a lot of paperwork that has to be filed for that. Also, the topic of intellectual property, copyright, we all are familiar with that. You can't download music off the internet. Everyone learned that by all of the high-profile cases. However, there's other things that you download, and there's other activities that you do that involve intellectual property. The use of a logo, the use of a picture. Sometimes even the color combination of a screen that you're making might actually be protected. The use of I, you can't say, my I program or something. Certainly even vocabulary words you can't use because they're protected. So I'm also going to cover a little bit about the intellectual property. What is copyright, patent, trademark, and trade secrets? Is it associated with software development? The concept of contracts and licenses. Although no one has ever read it, everybody has always signed a license. Anytime you ever installed anything. In fact, most people, would just click through it so fast they probably didn't even see that it was a license agreement because it's required to be there. I know you guys have seen it before, whether you've read it. The concept of piracy, freedom of speech, limitations, complex issues, ISPs, e-commerce, a couple of miscellaneous concepts. Business law, not very much. I won't get very much into business law in terms of this lecture. But in terms of statutes and precedents, here's what ends up happening is the do-it-yourself lawyers or the do-it-yourself software engineers who go out and read everything and they know the answers to everything. And what ends up happening is they have misinterpretations sometimes of different things. And you end up doing something and then you find out after the fact that what you've done is wrong. In fact, you don't find out until you get caught, and hopefully you will never get caught, hopefully. Because the fines on this stuff is extremely high, actually, in the U.S. So you don't want to get caught. We follow a common law system. Law is a combination of statutes or bills and precedents, judgments, things that have come through the line. And as a recent example, this whole thing that about 5-10 years back with Napster, with downloading music and peer-to-peer kind of file sharing. You know, before that, there wasn't the law, actually. That was something that came about, and said, well, okay, wait a minute now, we have to file this, now it's wrong, so now you can't do it. So what ended up happening is sometimes people develop software programs and utilities, and from a software engineering perspective, you want to make something that's cutting edge, right? You don't want to produce software that's already on the market. So you're always trying something new, hopefully. You're being inventive. But what ends up happening is that depending upon what you're doing, it might be stepping over the line. It might be crossing over into some legal issue that you may not even be aware of. So what ends up happening in that particular case is you usually get away with it until they discover it or until someone comes down and says, hey, you know what, this is really wrong. You can't do peer-to-peer file sharing. I mean, there was nothing wrong with Napster when it first came out. However, when that was invented and that was being used, that was perfectly normal. In fact, people were encouraged and tons of people were using it until someone decided that it was wrong. So you're going to come up with a software application that's going to do something like that, and then hopefully you won't, or maybe you will. That's how good stuff gets invented, actually. So hopefully you'll come up with something unique, but then what will end up happening is you'll kind of experience legislation. You'll, as an example, looking at the statutes themselves, reading the codes, it all reads like Greek. In fact, you can go online as a software engineer. I'll show you a website, actually, where you can actually come up with your own software license stuff. And it's an organization that's out there to support software engineers. And there's tons of legal code you can read through. The only problem is you guys are software engineers. You're not legal people. Half of you probably don't have a business background either. So the interpretation of all that stuff is pretty tricky, actually. And a lot of it may not actually even make any sense to you. So don't assume that your interpretation or the interpretation by the court is what you expect from reading it. Sometimes there's kind of a slightly different issue as well. So then we have change that occurs as well. As I mentioned before, that change with the Napster whole situation, sharing content. We're actually getting a change now with ebooks in the way that they're distributed, digitally signed files versus reproduced files. Because I guarantee it, everybody in the room has probably downloaded an ebook from some site, some BitTorrent or something like that, that may or may not necessarily have been something that you actually purchased. It's very common, but right now there's nothing to protect that, actually. But there's new legislation that's coming into place that will hopefully put some sort of a digital signature on the file, so that, let's say, for example, government, somebody wants to look at your computer, they look at your computer, how are they going to know that you downloaded that from a BitTorrent? Or not to say that all BitTorrents are bad, but BitTorrents are used a lot for downloading illegal content. Or how do you know you bought that from Amazon? Or how do you know where it came from? So digitally signing files and things of that nature, putting it, some protection on the actual content of it is one form that they're thinking about doing. It hasn't been universally decided upon yet, because it kind of goes back to that whole digital rights management, if you remember that. That's how iTunes originally started out. Everything had digital DRM coded on it, and then you downloaded it, your computer died, you got a new computer, can't transfer it, and there was issues with that. And plus also made the file size big. You're downloading something from the internet, it's huge in size, it's going to take longer. In fact, I'm not quite sure why they did it, because it was kind of drastic. They just got rid of it. Like in 1 month, they got rid of all the DRM. Everything now is free to copy, to distribute all over wherever you want to. which was actually kind of a nice idea, considering that their competitors weren't using DRM. So, and then I think Sony actually tried this out as well. In fact, a lot of the old Sony CD discs, compact discs, have DRM on it. So it's a little file. If you don't know what DRM is, look it up on the internet. Digital rights management. It's a way of protecting it. But that's old technology. So, as times are changing, legal systems changing a little bit, we're getting some new techniques, and new techniques haven't quite been invented yet, or they've been invented. Some experimentation's been going on, but they're not quite in full force yet. That's what I'm trying to say. So changes in the law usually follow with the technical world. So as we see different changes in technology, we see different changes in the law, different capabilities and stuff like that. Whereas politicians, they typically have poor technical backgrounds. So this is the interesting case. So you're sitting in a software engineering seat, and you have a totally different background, totally different way of thinking about it than a person who's sitting in a business seat or a lawyer's seat. It's kind of different, actually. It's like two opposites looking at the problem and trying to figure out a solution to it. So you're always, believe it or not, in controversy. You're always on the opposite side of whatever's going to work. Because you want to be inventive. You're using technology, hopefully, to make an advancement in the world. And they're trying to protect it. They're backwards. They're behind you, trying to figure out what's going on and catch up with you. So that's why I say it's not until you put it out on the market that someone actually notices it and says, oh, this is wrong. Oh, okay. And usually there's no penalty to that until you know it's wrong. And then when you know it's wrong, then when you develop something, then that's when you end up getting in trouble for it in the long run. But it's pretty safe to put cutting-edge technology out there. It's just not safe after it's been discovered, if it's doing something that steps over the line. So the interpretation of many laws is unclear as well, and so it often needs to be tested out. And a good thing about that is it usually works in your benefit, because it's really hard to prove something. Okay, so as an instructor, when I get programming assignments from students, I can pretty much tell when two students have written the same thing, when two students have turned in the same thing, didn't write it themselves. It's called plagiarism, actually, or I don't know what they call that, cheating. So you can actually, that happens in the real world, believe it or not. In fact, there was something recently with a company that a software engineer pretty much stole source code from another program. So that ends up being an issue. And then, or they steal it, but they change it slightly. Or what ends up happening is they take something that's open source, they embed it inside of the code, and then they try to pass it off as their code when it really isn't their code, it's open source. So those are some of the common issues with source code writing. There's other issues with graphics, with colors, with themes, with trademarks. Because it's kind of like building a website. When amateurs, when they build websites, they download images, they borrow stuff, and then they put it up. Inexperienced programmers that do the same thing. They borrow stuff. They copy the look and feel of something. The look and feel of something is protected, actually, or can be protected. So when you start thinking about all the different angles, how the legal system kind of plays a part in software engineering, then you start noticing, wow, it is a huge role. It's a huge part of what gets developed out there. So let's see, laws usually develop incrementally as well as another point, because we can't do everything overnight. So every year something new comes out. Is it a crime to steal somebody's wireless signal right now? Actually, they're trying to make it a crime. But right now, unless somebody's got protection on it, it's password protected. If I'm driving down a block and I have my iPhone out or something, and I pick up a Wi-Fi signal, I'm going to use it. But who's to tell me that's right or wrong? So, as eventually, hopefully, that will be decided upon. But that's another controversial kind of issue as well, as an example. So as a result, strange anomalies are often been made between technology and the real world and old world, and all different types of solutions that exist out there. All right, so now we have the jurisdiction. As I mentioned before, we're developing it in the United States. Is it good elsewhere, vice versa? Copying stuff, moving stuff across borders. We also have this thing called the internet that causes problems, because how do we know the boundaries in terms of where something is located and how is something being distributed over the internet? Because we're downloading, right? So we're going to a website, we're downloading something. Where are you downloading it from? You know, it's actually plays an important part with the law in terms of e-commerce as well. If you're a business or if you have a business background and you think about the concept of trade over the internet, some states in the United States, some states have sales tax, some of them don't. So, example, state of Nevada, there's no sales tax. So, when you get a P.O. box in Nevada, you put up your website and you don't charge your customers sales tax. So, okay, so you're distributing software. And the software you're borrowing from somebody else that's licensed by somebody else, but that's over there. So you open up a P.O. box over here, you put up your website and you download the software. So there's a lot of different interesting issues that come up in terms of a location and how you're going to break things up and how you're going to legislate the internet in terms of software and what rights might belong there. So if you break a law in Finland, do you know where on the internet in the United States, you know, what happens to you, you know? Actually, yeah, there's tons of Canadian drug companies that sell drugs, prescription drugs in the United States on the internet. Well, some of them are real, some of them are fake. There's a bunch of different issues with that. And what if you're in California and you break a law in Minnesota or another state? And that's the interesting thing. There aren't that many laws in regards to software. The only big one we think about is downloading copyrighted material. But we can't even figure out how to legislate that either, actually. So it's kind of immature. In fact, in the last point on the slide, you know, where do you pay the taxes? And I don't really know that many e-commerce people who are jumping out and asking people, how do I pay my taxes on this? How do I pay taxes? It's usually, don't say anything until they catch you. And then, oh, I owe taxes? Oh, I'm sorry, I didn't know that. Yeah, so it's kind of like the way things work, actually, unfortunately, because no one wants to, you know, cause trouble or make waves for anybody else. So a lot of weird stuff happens in the software industry, actually, you know, streaming video, translating audio, and you're like, you know, am I changing it? I'm adding something to it. Think about all the remixes they make out there. An artist comes out with a good song, somebody else adds a different beat to it, makes it into a dance tune or something, you know. It's like, oh, can they do that? It's kind of like how software works as well. When someone comes up with a technique for doing something, they discovered how to do a scanner, you know, how to print something out, how to convert a Word file to a PDF file or something. Can you do that? Legally, no, actually you can't, without getting a license from Adobe for using their PDF format. So there's a lot of hidden things that a lot of people don't think about. The United States, let's say 2 bullet points on the bottom here, has federal laws that cover the entire United States and 50 states with their own laws. Relationship between U.S. laws and international laws is complex and changing. Actually, we see that with import-outport stuff. In fact, it's really hard to get, for some reason, discs, compact discs, big issue. Which is why the internet's great for distributing software, because you don't have to send out a disk. Just download it. So in the old days, there was other problems with disks and stuff. All right, so the federal court system, I'm not going to go through all this, just a brief mention of it. You could take a history course, or you could take a business law course and learn everything you wanted to know about the federal and state, local kind of government. It's a little bit different in the U.S. where you're not familiar with it, perhaps. We're based by the Constitution, obviously. And because you're foreigners, it's, you know, probably reasonable to mention a little bit about this. International treaties, also federal and state statutes, proceedings. When it comes to the internet, it can't be regulated on a state level. It's normally federal because it crosses state lines. So most of the federal government, and if you remember anything about this, federal is more strict than state. Federal can throw you in jail, state can slap you on the wrist. So it's a little bit more serious when you're dealing with a federal level. And then unfortunately, software development usually goes up to the federal level because the states don't know how to handle it, and it's not normally a state issue. Because you developed, if you think about the product, if you develop something in the state of California, but you're selling it in other states, and what does it mean if you actually develop because you were physically living here? The software almost has like an existence of its own that is not really associated with a location in terms of its development. It's kind of like building a product. The same concept actually exists. And then when you start crossing over state lines, and federal government takes over. So there's 13 circuits, and there's also a Court of Appeals, yada yada. I'm not going to cover the legal system. What I want to cover, though, is intellectual property in terms of what it is. So by definition, copyright is a federal, as I mentioned before, most of this stuff is all federal related. It applies towards literary works, which is why we always have copyrighted books. When you write something, it can get copyrighted. So originally implies textual material, source code. Can source code be copyrighted? No. Actually, yes and no. It's very difficult to actually get it copyrighted, but it is by default copyrighted. But the problem is source code doesn't stay as source code, it gets turned into binary code. So it doesn't actually fit right into the whole concept. When you read a book, when you write a book and you write text, you can see it. When you read it, you can see it. When people use it, you can actually see what, you can, if there was a famous quote out of a book and I used it without providing the reference to whoever wrote it, I'd be copyright violation, essentially, which is why that's plagiarism. And when you take something that somebody else wrote and pass it off as yourself, because you're violating copyright protection. But what happens with software? Software is kind of interesting because it's digital media, and it's written, because we all know how to compile stuff for software engineers. And if it gets compiled to a binary code, is it still written material? So it doesn't actually fall into the traditional type of system when you're looking at source code and copyright. There's a little problem with that from the literal kind of translation. But music, so cover text, music, photographs, designs, software does fall into a copyright category. It's extremely hard to define into copyright. It applies to expressions of ideas as well. So when we write a book, we are expressing our ideas in words. When we write software, we're creating an algorithm. Is it our algorithm? No, somebody else's algorithm. Unless you happen to be an inventor of algorithms, almost everything's been done at this point. You might come up with a new one. You might actually come up with an ingenious way of doing a different variation of a bubble sort or something, or I don't know, something brand new. But if you're using somebody else's, you're using your copyright violation. In essence, if you translate it directly from printed material to software, you're breaking a bunch of laws, which is why you can't really do that translation. I mean, everyone does a linear search, a binary search. Those are they're not really copyrighted. I mean, because if they were, in the code you'd have to be saying who invented this, and giving credit. And then in the credits, could you imagine how long the credits would be on a program that you wrote? I mean, unless you invented all of those techniques yourself. So even using a software language and using third-party libraries, if you imagine that. You bought a tool that works with a mouse, and you're writing using a third-party library in your software, importing these libraries. They're not yours, but you're shipping them. In that case, what ends up happening is the third-party library comes up with an agreement. You pay runtime licenses, or you pay an agreement to distribute that particular library file that's needed for your program to work. Those are costly. That will cost you a lot of money, actually, in the long run. So anytime you're using a library, you're using some tool that you're using inside of your source code to make your work, to make an interface, a driver, something of that nature, if you're not paying a royalty fee, if you're not paying a license fee, you're breaking the law, essentially, because somebody owns it. Somebody needs to collect on it. So normally, not a bad idea, especially if you're working at a little startup company. Find out if the company is actually allowed to distribute the drivers, or to package, or to include something in your software that you're actually selling to somebody else. Giving it away for free is a different story. But if you're selling it, then you're violating some laws in terms of copyright. So copyright applies to the expression of ideas, words used, not to the ideas themselves, nor to the physical items, actually. So the driver file itself doesn't have any protection. The algorithm used inside of the driver file does, in terms of its idea. If you write your own driver file that does exactly the same thing as the third-party library, you're breaking the law. So there's a lot of sticky little areas, actually, and some of it, depending upon how the court rules on it, can go one way or the other. Depends on the extent of how much copying you've done, the extent of how much usage, what percentage of it is proprietary among the software development company, which percentage of it came from the outside. That's something that goes one way or the other. And then you always have the cases in which you have, I'm going to write another version of Microsoft Word, and I'm going to put Microsoft Word on the market. And eventually what's going to happen is, Microsoft's going to come back and say, no, you can't do that. And they're going to fight you. And they're going to, they're going to try and say you copied Word. But, mine's a different color. Or mine uses a different font or something, But, nah, there's people that actually do that every day. And it's a very difficult cases to actually try and nobody really even bothers. Because if you think about the life of software, it's very short. Your program's out, so out for a couple of years, it's gone. Unless you upgrade it, unless you put something else out. If you think about all the applications you're using today, they're not the same applications you were using a couple of years ago. Well, some of them might be, but most of them have changed, have grown. Even your web browsers are different than they used to be. So, all right, so the quote on the bottom here, software, copyright applies to the program instructions, but not to the concept behind the instructions. Nor to the files on the disk or the paper where the program instructions are stored. That stuff's not. Just, it's the program instructions, essentially. So it's a fine line if you think about it. So ownership in the U.S. at creation, copyright is automatically owned by the creator. There's nothing to do for it, actually. So when you write something, you put your name on it, you copyrighted it. That's essentially the process right there. Which is why you'll see elaborate source code documentation, hopefully. Which is how a lot of companies promote internal documentation. Right there at the top of the header, you must put the company information, the version number, the series, the date you wrote it on, and all this stuff that comes on the template. Because it's part of the copyright process, actually. It kind of documents that you wrote this and that this company owns it. Except work for hire, where employer owns the copyright as well. So in some cases, the programmer might actually own it. In other cases, the company actually owns it. When you go to work for a company and you're writing something for them, they own it, whether you wrote it or not. If you're writing it yourself and you're contracted out to give it to the company owns it, actually, not you. Which is why a lot of outsourcing issues have become problems lately, is because what ends up happening is, one company goes to this outsourced company, and this outsourced company writes software. And they write it for a lot of companies, and they reuse code all over the place, so who owns it? Well, the outsourced company thinks they own it, but essentially whoever they sold it to first, I guess, owns it. And they could probably go back and sue everybody else who's using the same code for something, which nobody really does, but they could, essentially. So that causes a lot of issues. So the transfer of the copyright in the United States, copyright is property that can be sold or licensed, actually. So what ends up happening is every time you download a piece of software, you install it on your computer, or you install it, you don't have to worry about downloading it. Actually, sometimes when you download it, you have to sign an agreement. When you click the little box, you click the accept, whatever. What you're doing is you're accepting a license is what you're doing. And if you've actually paid for it, you get the license. The license says you're allowed to use the software, you don't own it. Nobody ever buys software. What you buy is a license to use the software. You never actually own anything on your computer. Nothing is owned by you. Except for the computer, maybe, if you're lucky. So, all right, so the agreement is to sell is written as a contract. There's usually a date on it. In fact, you can find books on how to write software license agreements. They're contracts. They have certain parts that need to exist. A verbal contract isn't worth the paper that it's written on. Well, it's not written on paper, so, so you can imagine that quote. So we have some international differences, and it's usually a difference in interpretation, actually, that exists. So if you compare the United States elsewhere, in some countries, Canada, France, the creator of the work retains moral rights. They call them moral rights, which cannot be sold. For instance, the right of attribution, to attribute to it. In terms of the registration, that's what we get in the U.S. We register. That's why you fill out registration forms, and you have to actually, give out your name and your address. What you're doing is you're signing up to license the software. And so in the United States, copyright is established automatically when something is created. And then in many countries, it's necessary for the creator to register to a claim of copyright. And I'll show you a screen at a company that you can actually do that yourself. It's pretty free, actually. There's no expense involved with copyright. Actually, it's kind of automatic and kind of free. So in the United States, copyright gives the owner exclusive rights. So the owner of it has exclusive rights to reproduce, distribute, perform, display, and license to others to reproduce. So you have ultimate rights to it, which means if somebody else is reproducing it, they're breaking your copyright violation. So technically, when you have taken a disc and you've made a copy of it and you've given it to somebody else, you've broken the law, essentially. That's how that comes into play. Unless you actually created the disc yourself. And then you have to look at what's on the disc. And then you have to go through the files on the disc and see, well, where did these files come from? And then obviously you can see a bunch of issues that might arise out of that as well. So special exceptions may be the first sale. And this is exceptions to exclusive rights that might exist. So the owner of an object, a book, can sell the object without permission of the copyright owner. And then fair use, the limited use is permitted without permission of the copyright owner in a preview or short quotation. That would be, as an example, when you avoid plagiarism, when you actually, in a copyrighted book that you're quoting, if you're using fair use, you can use it. This is how GNU license works with open source. It's fair use. So you didn't write it, somebody else wrote it. In fact, open source is written by everybody. Everybody contributes to it. Everyone distributes the fair use policy, which is the GNU license, which tells everybody that you're only using it for the advancement of education or for the advancement of computing, and you're not selling this piece of software. If you include that in something that's being sold, there's actually different ways of getting around that. You can actually include open source with for sale software if you do it correctly without breaking any laws, which a lot of people do actually, and which brings us to the point, and it's actually called derived or derivative software, which is derived out of libraries, tools, open source, other pieces of information that exist out there that you didn't create, that you don't own. Because here's what happens. Normally you're going to use something. If it's a driver, if it's a library, if it's a mechanism. Let's say you're doing MP3 encoding. You're going to use somebody's algorithm to take this WAV file and turn it into an MP3 or something. You're not going to reinvent the wheel on that, hopefully. Otherwise, you're going to be spending way too much time reinventing the wheel, not enough time programming, not enough time getting your product out. So you're shipping something that's a combination of a lot of different things all put into one, which is where that word derivative comes from. It's derived out of multiple parts. When software is derived from other software, which is a very common case, actually, especially when you write something that works with something else. Copyright in a new code only is owned by the new developer, and the conditions that apply to the old code apply to the derived work. So actually everything is all separated out, even though it's all together, which is kind of weird. Which means if it still belongs to the old person, you have to get their permission, essentially, which is the same thing you do with other copyrighted material. If you want to put somebody's ebook on your website, all you have to do is write the author of the book, whoever owns the book, and say, hey, do I have your permission to put this on my website? And if he says yes, then you're not breaking any laws. And you keep that email, or you keep that piece. This is how people reproduce stuff. This is how books get reprinted. You get permission. So as long as you have permission, which is what you do with software, you get permission. And usually what ends up happening is the legal department of wherever you're working comes up with a form letter, sends it to the owner of the software and says, hey, we really like your driver. I think it's the best driver on earth. Can we use it? He comes back and says, yes. And that doesn't never happen. Instead he comes back and says, oh yeah, but you have to pay me royalties. That's usually what happens. Every copy of that software that you sell, you owe me 50 cents. All right. And then, and here's the payment method, blah, blah, blah. Which is generally how you make money in software, actually. If someone's using your stuff, you're getting paid for it, hopefully. If not, then you're giving away your talents for free. So if you write S, and which includes code that's derived from A, B, and C, and D, you can't distribute or license S unless you have rights from the copyright owners to distribute both A, B, C, and D, which means you got to get everybody on board. If one person's gone, And that person's got a claim against you, essentially. So in creating software products, you must have documented rights to every component that exists. How often do you think that happens? How many people actually think that everybody gets rights to everything that they're distributing? Or is it kind of a wait and see kind of thing? That's usually how that works. People put something out, because if you think about software engineering as a business, it doesn't take as much work or as much legislation as building a product or doing manufacturing or providing a service. You know, in the old days, people sat in their rooms or their garage and they wrote software over the weekend, you know. It's kind of less formalized, especially in the United States. It's less structure, less regulation, more informality to it. You know, you got people that are just writing stuff. Think about going back to that Social Network movie. You know, they're just sitting in a house writing stuff, coding all day. Nobody's regulating that. How do you know what they're putting in it? And, you know, actually, according to that movie, they got in trouble for stealing the idea, actually, which they did steal. So it doesn't matter how successful you are at it. If you're not doing it yourself, if you've stolen any part of it, eventually, the moral of the story is it's supposed to catch up with you, I guess. If you watch that movie. So copyright questions that you might ask yourself in terms of project work, and this is just as an example. You're a student at ITU, and you finished your project for some class. Actually, it's kind of like when you write a paper for a class, the same concept. You write source code for a class. And what use can you make of your work, and you know, what use is your client going to make of it? What use can ITU make of it, by contrast? And the good thing is that you own your own work. So, in fact, a lot of people do this in terms of graduate work. You know, you're working, in fact, probably not a concept that you've run into here, but maybe elsewhere. You're working on a project with another group of people, and the project actually is a good idea. You know, like you're developing an algorithm to do something that you might want to sell, maybe. Well, your other teammates or your other people that you're working with have a stake in that too. Which is interesting in terms of group work and that way the dynamic works. Over at ITU, though, you know, if you make something for a class, it's yours. So you own it. The work that you do for a class, anybody else, including ITU or the clients, need your permission before they're using any of that software, which is kind of interesting. Because if you think about the EMS system, and I'll only briefly make this a small example, actually. All the work that you're putting into that system actually technically belongs to you. Unless you've signed something, and I wouldn't be surprised if you haven't in the registration, perhaps, that said everything you're uploading belongs to the university, which is basically the way that you would actually give rights for somebody else to use whatever it is that you created. Not that anything, maybe your CSLO essays, maybe you really love them, maybe they're fantastic works of art that you want to protect because you want to, you know, to use them in the future. You would technically own them unless you gave them, unless you signed or gave permission, which, I don't know, I haven't been a student here, so I don't know. I mean, I haven't signed up the EMS to see, but I guarantee you if you start looking, there's probably something there written that says something, hopefully, about what rights, who owns what in terms of what you're uploading. So technically, believe it or not, when you upload a plagiarized assignment, that's actually breaking a law, because not only have you broken copyright protection, but as a student, you violated academic honesty because you uploaded something, claimed it was yours, and it wasn't yours. It's like lying kind of thing, you know. So it's actually pretty bad. In fact, most universities will throw you out for that. So because it breaks huge moral issues and huge problems. All right, so the feasibility study, the little quote on the bottom here of your project should include a commitment to your client, and full rights of the software developed, transfer ownership, stuff like that. So a lot of people get fancy. You see that, in fact, in the old days, you used to see this a lot in source code documentation at the top. It'll say, you know, written by Barbara Hecker for ITU University on this particular date for limited sole purposes of educational blah, blah, blah. And you have all this stuff spelled out. Because what you spell out is your protection, actually. And you come back and you can say, you guys used this. You published it in a book. You did this with it. Then you can come back and say, this is mine. It was for the sole purpose of online teaching. It had nothing to do with, you know, this or that or something else. So the purpose of the use that you're using the software for also matters. Which brings up another point that I didn't mention yet, or that I probably should have mentioned at this point, is when you download and use software, even if you've paid for it, if you're using it for something it wasn't intended to be used for, you're violating. So a lot of people would install BitTorrents. You can legally distribute a BitTorrent software package because the package itself is supposed to be used for sharing files with your friends that you own, that you guys have copyright protection for. If you go ahead and you use that package to download ebooks illegally, it's not the company's fault for selling you that package, that program that enabled you to do that. It's your use. So you violated the fair use of that particular package by applying it towards the downloading of illegal material instead of legal material, which was kind of the controversy if you were following it back in the old Napster days. They created a system, believe it or not, for peer-to-peer file sharing. So they weren't telling their users that they should be sharing illegal content. They just created, and it was that was the sticky fine line between, oh, what they do was right, or did what they do was wrong. It caused a little legal issue because the people used the software wrong. They weren't supposed to do that. So at that point, you're supposed to be able to prove, and this was the whole problem, what you're supposed to use it for. So if you create a piece of software that doesn't break any laws at all, but it does when people use it, it's up to you to actually come up with the correct usage and your intention for creating the software in a legal manner and not in an illegal manner, because if you do it illegally, then even if you're not doing it, but somebody's using your software to do it, you're still liable for it. Depends on your intentions for distributing the software, which is why you get the fine line between, we'll give you a BitTorrent package, but we're not going to ship with it sites for you to go to download illegal material. Or we'll give you an MP3 encoder, but we're not telling you what to encode or decode or do what with, or DRM removal software, but we're not giving you any DRM material to remove it on. We're just saying that it can be used for this or cannot, this is the other reason it can be used for. So here's some good questions to ask yourself, and I'll kind of go through them, and I get the answers on the next slide. When software is written, who owns the copyright? Interesting question. You probably can answer it yourself at this point. And how can somebody else be permitted to use the software, and how can a copyright be transferred to somebody else? The answer being the person who writes it owns it, and except work for hire, where the employer owns it, actually. Whenever you do work for somebody else, it's there, even though you wrote it. And which is kind of an interesting phenomenon, because that actually translates out into a lot of other careers as well. Let's say you're a salesperson and you're working for a company and you got a huge contact list of all of these clients that you've accumulated over the 5 years you've been at this company, and then you've decided to leave the company. Who owns your contact list? The company does. You don't own it, actually. You don't own anything that you do at work. So you're at a job and you've invented something, and it was in the course of your work that you were doing, you created this algorithm. So you get wise and say, oh, you know what, I'm going to go with my buddy over here. We're going to open up our own company, and we're going to use this thing that I invented here. And ends up happening is you end up getting closed down because your previous employer is going to come back and say, hey, you invented that on my time. You did it right here. It's mine. I own it. I get all the money you're making from your company. It happens all the time, believe it or not. People come up with all these ideas. Oh, yeah, I can do that. If you took the idea from a present employer and you're using it elsewhere outside of that employment scope, you're breaking the law. Happens with software all the time. People come up with these ideas, just the idea for making it, which is the whole Facebook problem right there. Just the concept or the idea taken, and you open up your own business, you might as well just give all your profits to your previous employer because they're going to take them eventually. So it's not worth it, actually. The only problem is how you're going to show. How are you going to show it came from you? How did it came from a previous employer? That's a problem. So somebody else can be using your software as long as you get permission, usually a license agreement, contract. There's form letters for that these days. It's kind of like a rental agreement. You know, so license agreements are a dime a dozen. You can find them everywhere. Copyrighted property can be sold or given away, usually by contract. You can actually sell software. That's what outsourcing companies do. That's how they get in trouble. They sell the same software to multiple people. It just has different modifications to it. And then they get in trouble eventually. So other good questions here. You are employed at company X, writing software. You leave the company. Who owns it? The company. It's work for hire. And let's see, what use can you make of the work? None, without the permission of the copyright owner. So otherwise you end up in problems. Let's see, you work for freelance. You're freelance for a company X. When you finish, who owns your work? Depends on the circumstances, actually. And do you have a written contract, actually? Interesting. Because here's what happens. So this is what I talked about in Software Engineering 1 last term. You know, you have a requirement specification or a statement of work. You have something that is serving as a contract at the beginning when you decide you're going to work for this company or you're going to build the software for these people. You know, they've come to you and say, hey, we need this built. That's your contract. So in there, there's actually something, you know, you can put in there. Upon completion, I own all rights to the software. You license it from me. Or on completion, you know, you own all rights to the software. I don't have any liability, because with rights become liabilities. So it's a trade-off. So let's say it's an accounting program that you're writing for somebody. And the accounting program is for Wells Fargo Bank, and they're putting it in. And there's a mathematical error in the algorithm for which every 12th customer gets $100 free or something like that in their account. And Wells Fargo goes back to you and says, hey, look, you owe me $3.5 billion because your error has been going on for 2 months and we just now found it and it's your fault. And then you go and you say, well, did you read the statement of scope? Did you read the requirement spec that I gave you? See at the bottom it says, all rights, liability is now yours. You bought it. It's yours. Do what you want with it. You want us to fix it? You have to hire us. We'll go fix it for you. Actually, it's not quite that easy, but it breaks down to that in the long run. Unless there's a written contract, there's no liability if there's no ownership. If you own it, let's say you want to get smart and say, well, you know what, I want these guys to pay me royalties for the rest of my life on using my software. I'm going to build it. I'm going to let them license it. Then Wells Fargo comes up and you say, you owe them $2.5 billion or whatever it is because they're licensing the software that you said was working, that was supposed to be working, that made an error. Depending upon how your contract's written and what you're actually licensing to them, if it's a service, if it's the software, use of the software, and depending upon what's in the license agreement, that's why if you take a look at some of those license agreements, they read like, Microsoft takes absolutely no responsibility for anything that goes wrong with your computer. Microsoft holds no liability for blah, blah, blah. Everything is like your fault. If you install something from Microsoft on your computer and you accidentally remove your dissertation that you've been writing for the last 2.5 years and you haven't finished yet, and it's gone completely, and you have no backup copy, it's your fault. It's not Microsoft's fault. So that's why how come you have those license agreements that are 3 or 4 pages long, and you wonder, why is that in there? Well, that's because they're covering their bases. I was going to say something else. They're covering their bases on everything. All right, so it depends on the circumstances, depends on has there been a written contract. And what use can you make of the work if you hold the copyright? Unrestricted use, actually. If you hold the copyright on it, you're a consulting company, you outsource software, you create software for companies and you own it, you can sell it to whoever you want to, you can license it to whoever you want to. If the person that you wrote it for wants the license, wants the ownership of it, you can't actually turn it around and sell it to somebody else, which is kind of the issue that happens because you don't know when you buy something, when you outsource it and you're buying something, do I own it? Do they own it? And half people don't even ask. They just go, oh yeah, here it is, here's your accounting program. Oh great, thank you. And then you find out that your competitor has the same accounting program. And they're using the same features you're using, you've lost your competitive advantage, you've got an issue with, this company sold me the same program that they sold them. If they own this program, they can sell it to whoever they want, actually. It's not your right to say that they can't. So it depends on who owns it. That's why you always want to own it. Because otherwise, if you outsource it and you don't own it, then everybody on the block is going to have the same program, essentially. Because if I were running an outsourced company and I was selling software, I'd sell everybody the same thing. Why reinvent the wheel every time I have to write it? So you want an accounting program? Here you go. Here's an accounting program. Here, I could give it to you in 2 days. Quickly. All right, otherwise, nothing without an agreement. Perhaps some minor use, under a fair use, perhaps. Who knows? Contracts and licenses. A license agreement is a contract. Contract has a time on it, actually. License agreement has a time on it. Actually, I believe Microsoft Windows operating systems have a time of 1 year, I think. It's a 1-year license agreement. Sometimes it used to be, in the old days, it used to be 2 years. I think it went back with Windows Vista. No, I can't remember. It was like a couple Windows versions ago, it got limited to 1 year license agreement, which means after a year, they don't have to support it anymore. So here's what happens. You're an outsourced company, you create a software package, you give it to somebody, they license it, which means they can use it. How many computers, how many people can use it? It depends on how you've written the license. How long? Because after a certain point, do you really want to support them anymore? And is the support included in the license agreement, or is it extra? Because you have maintenance to think about, adaptation, new operating systems. If you buy something from Microsoft, it's good for a year. If it works, great. If it doesn't, you call them up, and they're actually legally required to fix a problem if they know about it, and they'll fix the problem, and they'll give you a patch. This is how patches and bug fixes and stuff come out. After a year, you're no longer entitled to free patches and bug fixes and stuff. You have to go buy them. So this is kind of like a way of releasing software with an expectation of future sales. Because just because I have Windows version 1 doesn't necessarily mean I get Windows version 2 when it comes out, or 3. You have to go out and buy them again. And then this concept of upgrades came into play, upgrade license. That's kind of a made-up concept. It has nothing to do with copyright, nothing to do with licensing. It's kind of a fictitious, kind of made-up kind of concept that people use to sell software. Because they figure, oh, we'll give them a deal. They bought Windows once. Let's let them upgrade. Give them a little discount off the next one. And then I like the student licenses, actually. That's a made-up concept as well. There's no right as a student to get a discount on anything. So, but, software companies say, oh, let's make up this little student license, maybe, so they can get it for a student discount. All right, so contracts allow intellectual property to be sold by concept. Economic agreement in exchange for some consideration, usually money, or it may also be the use of something else. So you can make an agreement with a software company to use their drivers if they can use your program, which is companies like, let's say, for example, HP. So when HP first started selling drivers, started selling scanners. Interesting phenomena. If you've got a scanner, you guys know what scanners are. In the old days, we had to have programs that used with the scanner. You're HP, you want to sell a scanner, you have to have software. There's no software. Nobody's created it yet because you just created the scanner. So you partner up with another company and says, well, we'll ship out your software with our scanner. You can use our driver for free. So it's kind of a trade-off. Or if they buy the scanner software, they can get a discount off of the scanner hardware or something. So a lot of companies actually team up like this that make accessories that are software-oriented to hardware and vice versa. It's a great way of, that's how drivers get distributed. It's a great way of selling something with something that's going to work with it. And you get the best of both worlds. You usually have a written agreement with signatures. Is it something permanent, temporary, whole or part, exclusive, non-exclusive, termination, problems, difficulties? If your scanners are being shipped out with this software written by XYZ company, can you also put on the same disk something from ABC company, Actually, you can write that in the agreement. It says, if you're going to sell my software with your scanners, you can't sell anybody else's software. So kind of an exclusive kind of a deal with that. And you can see there's probably a lot of different characteristics that you can actually add with that as well, a lot of different things. And basically, contracts, licenses are enforceable in court. So if you were, in fact, this happened actually probably about 10 years ago by now. back when the software police were popular, this is before they had to worry about digital rights and media and the internet. This is before the internet was really the mainstream. Way back in the, I guess I think the early 90s, late 80s, there used to be these consulting companies that, well, it was rumored that Microsoft hired them, but I don't know if that was actually true. This might just be a bad rumor I'm spreading again. But the concept was they sent out spies to organizations to see what was on the network. And sometimes what ended up happening, in the old days, you know, you bought a piece of software, you could copy it as many times as you wanted to. So people would go and they'd buy one copy of Microsoft Office and 2,000 people would be using it. And it'd be installed all over their computers, all over the company. And you know, all you have to do is go into the About box, look at the serial number. So they hired these spies essentially to come in and say how many computers are all using the same license copy, and how many, because what you did is you'd install it on a network drive, you know, and everybody downloaded it and everybody installed it. And all the computers had the same software on it, but only one license was purchased. So long story short, companies got wise and they decided to build the restrictions and limitations into the software. But before this was happening, they'd send out spies, for example, and the company would get a bill in the mail from Microsoft Corporation. You owe us $2 billion for 25,000 unlicensed copies of software that you're using. You violated our software license agreement, blah, 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 blah. And actually, it's a legal statement. They have to pay it. It's a legal bill. They violated the software agreement. That's a 1 computer, 2 computer, 3 computer, whatever it happened to have been. They used it on 250 computers. And actually, it's a great way of generating revenue because people were just freely copying everything. So, you know, now people don't waste their time doing that anymore, actually, because it's just a waste of time now because people have so many different ways of getting around stuff. So, all right, Creative Commons. This is the website I was talking about and mentioned earlier. You can go to www.creativecommons.org, and you can actually choose and create licenses and find out a bunch of information about copyright restrictions and stuff. It's not a bad reference, not a bad place to go to learn more about the stuff I've been talking about in terms of contracts, license agreements, trade, stuff like that. And it also allows you to learn how to document and how to copyright your material, your source code, and how to do everything legally. And the more you follow the standards, the easier it is to collect when somebody does violate you. Because what you don't want to do is go through the motions, think you have protection, and then lo and behold, you don't have any protection, and all your hard work is out on the internet, and everybody's using it. And everyone's downloading your book, but nobody's actually paid you any money for your book. So, and not to sound like a radio advertisement, but copyright's bad. I mean, copyright infringement is bad. Bad for the economy, actually. So. All right, so, whoops, there we go. That's everything you ever wanted to know about copyrights as it applies towards software. So hopefully you walk away with a kind of that understanding that software is copyrightable, but it's tricky. You have to actually go through and follow through the process correctly to protect yourself. So let's switch gears a little bit and talk about the concept of a patent, which is different than a copyright, because people can use your patent no problem at all. All you're doing essentially when you patent something is saying that it's yours, you invented it, which is kind of different than copyright, because you can't invent words. So copyright, in fact, if you go back to this website, it's called Creative Commons. Copyright is more of a creativity, it's more of an activity in which you have uniquely identified, uniquely documented, uniquely created something, and software is very prone to that kind of environment. Patents are a bit different. So patents, actually, if you apply for it, what you're doing is you're documenting your invention. And it's the exact opposite, believe it or not, than a copyright. Copyright has all this protection. It's right protected. Patent is the exact opposite. It's here it is, this is how you do it, this is how you implement it. This is a product that uses it. You give away everything. If you give away everything, in return for giving away all the secrets, you get recognition for inventing it. That's essentially what a patent's all about. You cannot patent software. It doesn't work correctly. Actually, I shouldn't say that. You can. It's very difficult to go through the process because it doesn't follow the same traditional patterns as other inventions. So a patent itself requires complex processes. There's an entire application that you fill out. 17 years to be awarded, 20 years from the application point. It's a long process. It goes through a couple of different stages. And as opposed to copyright, copyright applies to the expression of the ideas, patents to the ideas themselves. So in terms of the copyright, that's why I went back and I showed you that Creative Commons. It's the creative use of it. It's the expression. Patent is the idea. So if you actually, and you can patent algorithms actually, you can patent software techniques, you can patent software and hardware combinations. And the trick to the whole thing is that if you actually go through it correctly, then what ends up happening is you follow through a pretty rigorous process for about, I don't know, 10 years or so on average before you actually get approved or you get it published. And then what ends up happening in the long run is it's only for recognition. Anyone who wants to can use it because you've given away the trade secrets, actually. All this does is to give you proper credit. So don't think you're actually going to make money from this. There's absolutely no money. Copyright, that's where you make the money. If you copyright and you license and you allow people to use your copyrighted material, that's where the revenue comes in. Patent, that's where the inventors, that's where the Einsteins be able to like show that they're smart or something. I mean, it's just, and in the entire process of getting the patent, you're disclosing everything. It's a disclosure of your idea, disclosure of the invention. And actually the purpose of it is to foster growth and invention. I mean, we wouldn't have electricity, we wouldn't have fire, we wouldn't have all these things that we have today if people didn't invent. And so we've given proper credit to inventors throughout history, and that's just a continuation of the process, which is why software kind of is hard to patent because it doesn't really fall into the traditional style of invention. What usually ends up being a more popular invention is a three-legged chair instead of a four-legged one, or the concept of a remote control, or the concept of a video projection or something. And it's usually just someone coming up with a unique idea that didn't exist before. So, all right, so software package, there's a problem with patents. Let me tell you a little bit more about the problem issues. Poor quality of patent examiners can lead to broad patents for routine computing concepts. Major, major problem, which is why they've kind of slowed down. In the beginning, when software engineering was kind of popular, Silicon Valley, and things were really booming, especially here in California, every day, you know, patents were being filed for, oh yeah, we created this new algorithm, we created this, we created that. Now it's kind of slowed down, tapered off a little bit, because they're all the same. They're too broad. You know, just because you created an algorithm that does sorting, that person does one that's sorting, that one does sorting. You can't differentiate. Plus, these people are not software engineers. These people are business people, law people that don't understand, for the most part, average don't understand software engineering. They don't understand how to, they don't write source code for a living. They write patent applications. So it's kind of hard to find someone who can actually do it correctly. Usually difficult to know where the idea actually originated from. If you think about software in general and how you're taught how to write source code, you're taught how to do things, you know, iteration, loops. These concepts are taught to you. Where are they coming from? You know, did you come up with that? You know, okay, so now I have a for selection, you know, way of routing through the flow of my program instead of a 3, you know. It's kind of a derivative of everything else you've learned about coding in general. And it's actually kind of like a foreign language. You know, you can make up words, you can make up concepts, and that happens, and then you get that copyrighted, essentially. You don't patent it, you get it copyrighted. So that's my spiel on that. And there's also some international differences between patents, which makes it not so good. Copyright is more universally accepted and more recognized. It's more consistent with other countries. Patents are kind of unique per country, which means you could take something from country X and bring it over to country Y and patent it yourself, even though somebody else already patented it over there. So there's no actual international, acceptance of any general patent technique. And so the situation is a serious mess. Actually, that's a good point to put on the bottom, which is probably why I'm trying to get into it myself, actually. I'm trying to become a patent attorney one of these days. I'm still going to continue teaching, but this is definitely an area that interests me because there's so much growth potential. There's so many new things that haven't been discovered yet. So if you've been working in software engineering or computer science for years, things that pretty much are dead. They're tapered off. I mean, unless you write another internet application, what are you going to do? So a lot of people actually with science backgrounds are getting into the area of patents because intellectual property protection, because it's exciting. It's new. It's like all these challenges. It's almost like the start of the Silicon Valley boom all over again. And so it's exciting. It's because it's uncharted waters for the major industries. So, and plus we're at the beginning, which means, you know, somebody can invent the new way of protecting something, and somebody can invent, you know, the process for this, the process for that, because we don't have any rules. So, I mean, we have rules, but we don't have that many, and they're not doing a good job protecting software in general. So, all right, so that's everything you ever wanted to know about patents in 5 or 10 minutes. So here's everything you ever wanted to know about trade secrets in 5 or 10 minutes. So what I'm giving is a brief overview of all of these different subjects, actually. If you're interested, all you have to do is do a Google search. You can find a bunch of information on copyright, a bunch of information on patents. But there is a distinct difference between all of these different terms. Yes?
Is copyright really
Free?
Yeah.
What do you mean by free?
Is that what clearly copyrighted copyright?
Yeah.
I don't think so, because I have read a website which says like
Don't pay to have somebody copyright something for you.
it's like $100 for getting copyrighted.
The concept by nature is documented when you put your name on it, when you claim it is yours.
But we can claim, anybody can claim, they can say take some other word.
My advice, go to this website right here and read the information on the process and understand. You can actually copyright something for free. It's not a service that you want to pay someone to do. As soon as you sign your name on the bottom of it and claim that it is yours, you've copyrighted it, essentially. Patents are different. Patent, you actually have to file an application with a patent trademark office, and they have to go through and they have to validate and verify everything. When you've copyrighted something, you put your name on it and you've said it's mine, and it's up to somebody else to violate it. It's actually kind of the opposite, because already it's approved, already it's yours, unless it's not yours, unless you've stolen it. And then when somebody violates it, then you come back and you claim against it. And then that's when the legal process actually happens, is when someone violates your copyright and someone takes something that you did and turns it in as theirs. Then you have a problem with that. But my recommendation is go to this Creative Commons website, read about it. There's a link there to license. There's there's copyright information as well on this website, and or just do a Google search to type in copyright. In the old days, people used to write stuff to themselves, sign it, and mail it to themselves, and then keep it sealed. That's a copyright. Not so technical today, I mean, because you can mail fraud and stuff, but not that big of an issue. But that essentially documents and signs, and basically shows evidence that you came up with that, which is how a lot of the copyright works. When you publish something, you put it in print with your name on it, it's copyrighted, because what ends up happening is when somebody else uses it, you've got evidence. Here's this book I wrote in 19 whatever that has that quote in it that you used, that you said was yours, is mine. So you're claiming rights against it. So copyright is printed material traditionally, but it can apply to software, actually. So, all right, go to that website, it'll show you everything. Trade secrets and non-disclosure agreements. Oh, the non-disclosure agreement. That's a good one. Believe it or not, it is a form of protection for intellectual property rights, and everybody signs one if you don't. Well, actually, everyone goes to the internet, downloads a generic non-disclosure, puts their company name on it, and has you sign it. If you're doing consulting work, you're signing one of these. Hopefully, if you're not, more power to you. Because as soon as someone discloses their idea to you, unless you've signed a non-disclosure, you can go and use it. It's your idea. How can you show? And again, the bottom line to all of this is documentation. It's showing proof that you invented something, showing proof that it was your idea. The non-disclosure is that in a nutshell. Non-disclosure is anything I tell you about my idea to do X, Y, and Z belongs to me. And I'm letting you know because I need your help. I need you to work on this. This is where a lot of actually do-it-yourself software engineering people get into trouble as well, because they go to work for a company, they sign a non-disclosure. They go ahead and go, wow, look what they're doing. Wow, this is really cool. Well, I can do that. And then they steal it. They signed a non-disclosure, meaning they're not going to disclose this particular information that they were exposed to, but they learned it, they know it's in their head. Then they go to another company and they go, hey, you know what? At the other company I was working at, they were doing this, we should do this too. And then bottom line, company A finds out what company B did. Company B says back and says, oh, look at this common employee was working here, now is working here. And then the bottom line is the employee gets held responsible because they leaked out the private information from A to B, and now, now you're stuck. You're trying to be a do-gooder. You're like, oh yeah, this place does it this way. We should do it this way too. And yeah, it works well for them. It should work well for us too. And it's actually breaking the law if you signed a non-disclosure agreement. All right, so on the bottom here, trade secret. Oh, that's a long quote from the Uniform Trade Secret Act. Information including formula, pattern, compilation, program, device, method, techniques, or process that derives independent economic value from not being generally known or not being readily, ascertainable, subject, whatever, main secret. Read it yourself, you'll probably be more effective if you can see the slide from here. Example, Microsoft source code. That's trade secret, actually. Non-disclosure agreement is agreement not to disclose trade secret. So if you're not disclosing a trade secret, you haven't broken the non-disclosure agreement. If you're disclosing a trade secret, how someone is doing something, that's an issue. So now the bottom line is, well, what's a trade secret? And if you just listen to me butcher that definition, you see it says a lot of things in it. Formulas. So I don't know if you guys are familiar with Kentucky Fried Chicken, KFC, a fast food chain in the United States. Long time ago, they had an employee that was working one of the companies disclosed the trade secret. It was actually the crust. You know how they have the extra crispy and I don't know. I haven't eaten it in a long time. I don't know what they have nowadays. But there's a special formula. It's actually a series of 5 or 6 ingredients that go into the batter that go on an extra crunchy, that makes it extra crunchy. And I think it has cornflakes in it or something. He disclosed it. He actually put it on a website or something. He did something to it. Somebody over at KFC found out and went, that's a trade secret. You disclosed a trade secret. And it was a secret recipe. It's kind of like the Mrs. Fields secret recipe. If you're familiar with Mrs. Fields, that got out. All the secret recipes get out. They're not really a secret if they're out in the open. So, but nobody makes Kentucky Fried Chicken like Kentucky Fried Chicken. Or Mrs. Fields. Like, sometimes it's extra butter, extra salt. I don't know what's in the... I don't know what the trade secret is. We're not supposed to know what the trade secret is. We're just supposed to like it. And it differentiates that chicken company from that one, etc. and so forth. So people are held liable for disclosing a trade secret. It happens with software. And it's the strangest things. Using data structures, using a particular file format, using a certain process. If you think about how software is built, there's so many different components. Is everything a trade secret? And eventually what the bottom line is, it's whether the court determines whether it is a trade secret or not, as to whether or not it's an enforceable violation of that. So that could cause a lot of problems, actually. So a trade secret does not expire as long as it is kept secret. That's an interesting thing. So once you've signed a non-disclosure, there's no 1-year license agreement on it. There's no, it doesn't expire ever. Which means, someone can come back to you later. It never happens because software doesn't live that long. Software outdates itself every year. But let's say you were exposed to something, back in your youth, and now you're an old person and you gave it out. You can still get violated for it, or you could still be guilty of it. Competitors may not use secrets obtained through extraordinary means. Sending a spy in to go see what kind of recipe the Kentucky Fried Chicken people are using. So actually that's a great way of learning a lot of stuff. In fact, a lot of companies used to do that for a long time until they figured out, oh, That's a trade secret. Oh, you sent a spy in. Oh, you can't do that. Actually, a great way of figuring out anything is calling the receptionist, or walking in for a job interview, and then snooping down the aisles on the way. You don't really want the job. You're just there to see what's at the company, who's working there, how they have everything organized. Everybody copies everybody, it seems like, everywhere. So if you learn a trade secret when working for one employer, you must not disclose them to another employer, theoretically. It happens all the time, but it is against the law. All right, so that's trade secret. Now we have another concept called trademark. Trademark's an interesting one because you see the TM trademark. Sometimes you see the copyright symbol. 1995 copyright by Microsoft or whatever. Because all the symbols, whether they're valid or not, they're used to kind of show you we're thinking about it, or we may have copyrighted this. So this might be our trade symbol. Specific for a name or a phrase. So what differentiates all these things is it printed material? Is it an idea? Is it a name? So a trademark, iPhone is a trade. Anything is a trademark these days. So it's names, words, phrases. Where's the beef is a trademark. It's something that identifies a company, an object, a thing, a concept. It's not a copyright, it's not a patent. You can't patent iPhone or something. But you can use it. It's a name, it's a phrase. So essentially that's where it becomes a unique part of this entire intellectual property scheme. So unique within a line of business, perhaps. So that's the interesting thing with Apple. So, for computer parts, you can't really say anything unless you get approval. And that's how the trademark works. It's kind of like copyright. You get approval. You say, is it okay if we call our product iMouse or iPhone, headphones? You can't call headphones iPhones because it's like the iPhone product. There's going to be a conflict right there. Apple's not going to like that one. So any particular country, as an example here, only one electronic firm called Apple in the United States can, but could be shipping a line called Apple in the United States, Apple computers, or different electronics called Apples in another country, which means you can't come up with, you can't put a market, you can't put something on the market and call it an Apple computer. It's going to violate a trademark. Generic terms can't be trademarked. Windows is currently under dispute because they have it trademarked. But Windows is everything. Well, when you hear Windows, you think of Microsoft because that's their trademark, actually. But why you can't take Windows? It's like, here's the problem with trademarks. If everybody in the world was allowed to trademark every word, there'd be nothing left for anyone to use. So we have different types of windows. We have windows, like in a house. Those are windows. What if you're making a different product, but you're using a window in the word of the product or something, and you want to use that? You can't trademark it. The way trademark work is somebody owns the trademark, you can't go back and trademark it again. Kind of like a patent. Once somebody does a patent on something, somebody else can't do another patent on the same thing. It has to be different. It has to be unique. Trademarks are supposed to be unique as well. But rather than an invention, they're words that are being used. So trademarks can be lost if they are not defended or used. So as an example, lost trademarks are aspirin, Kleenex, Q-tips. Actually, is a good one too. When you think of a cotton swab, who calls them cotton swabs? They call them Q-tips. Q-tips, but you see Q-tips written, you'll never see it written on a package, actually. You'll see cotton swabs. You only see Q-tips written on Q-tip brand cotton swabs. That one, the trademark is not lost. That one is actually still valid. So you can't put a product out and call it Q-tips. It has to be called cotton swab. However, aspirin is generic. It's lost it, and how it lost it was people used it, and the company didn't complain. So trademarks are a little different than copyright, because in copyright, if people go out and start using your material, the more they use it, the more defense you have. Because then you come back and you say, look, here it is, years down the road. You copyright it, and then there's no expiration on that. Trademarks are the opposite. If you keep calling things aspirin, and the company lets you, and they're aware of it, and everyone's calling it aspirin, it becomes aspirin. It becomes an okay word, no longer trademark. They lose it. So things in the software industry, it applies a little bit, usually just towards the name of products. You know, antivirus software is not trademarked anymore. It was at one point. Anti-something was. The I is another piece of controversy because there's I everything out now. And because there's I everything out and Apple doesn't complain, it's no longer a trademark. You can use I for anything you want. You can't put the word Apple on something. They're gonna basically freak out on that one. Held trademarks Coke and Pepsi. You can't call something Coke because they're going to come back and they're going to sue you on that one. All right, privacy. Getting down here in terms of invasion of privacy, intrusion, appropriation, likeness. You get this a lot in the software industry because what differentiates, well, in the old days, one word processor from another word processor program, or one accounting program from another accounting program. So what ends up happening is you write another Microsoft Word, you put it out in the market. It's not called Microsoft Word, but it looks like Microsoft Word. It's called misappropriation. If you're using Microsoft Word as a word processor as a concept, but you don't own it, and you're resembling it, you can also do false light. You can put a product out there that's a spoof on another product, essentially, or another program that works just like it, but it isn't. You could portray a product. In fact, competitors do this all the time. Say, oh, their software, this is why in the old days we saw more product comparisons. Now companies come back and say, you can't say that about my product. You know, in the old days you bought a box of, when you bought software, on the back of the box. Actually, I shouldn't say that. You guys buy software now too. You pay for it when you download it. When you used to buy it in the store, on the back of the box, it had our product and then 5 of the different competitors' products, and then you have a column, like a tab, like a table with some check marks. Well, we provide this, and we provide this, and we provide this. And obviously, they're only giving you the categories that the software you're buying provides, and there's a check mark that goes all the way down on one column. The column next to it is half empty. Now, if you did that, and you're wrong, now you get stuck with false light. You're giving a bad impression of somebody else's software, and you're going to be held liable for it because there's privacy associated with that in terms of privacy rights, and it falls under that whole area of privacy because you can't say something that's wrong about another piece of software. So that's why all the product comparisons went away because people were going, wait a minute, our software does this. What version did you look at? You know, our software does this too, and our software does it. Because everybody wants to do the same thing. Everyone wants to be compatible. And everybody else wants to be in competition with each other. So, all right. We're getting towards the end of this for these people who are getting antsy. So, be careful about collecting personal data without the knowledge of the individual as well. There's actually new legislation that goes even more current than this slide set that goes into the concept of what you can use information for, and that's a whole separate set of data protection rights in terms of actually starting in the year 2000 when most of those acts came into place in the United States that said you're not allowed to store information about customers, you're not allowed to store more than one piece of information, how long you can store something for, and what you can store. So there's a lot of different legislations as well about privacy of children, people under the age of 18 in the United States. That might come into play if you're hosting a website and you are storing information about minors on the website. Maybe it's Facebook or something, and you haven't clicked on the I'm over 18. This is how you end up with sometimes those little boxes you have to check, and you're wondering, why do I have to be over 18 to use this Facebook website or to use that? It's because you're putting information up, you're storing information as a company in your software about minors. And in the United States, there's laws that protect the minors in that aspect. You can't store information about them. So you have to, I'm over 18. So if the minor clicked the box that said they were over 18, just like you can't show pornography to people under 18, if they click the box, they click the box. That means they lied. It's their fault, not your fault. So there's a lot of controversy over the restrictions associated with some of those websites, especially some of the pornography websites. It's too easy to get in, essentially, by saying, oh, yeah, okay, and then you get in. So, all right, public and private information, in terms of software engineering, a lot of public information is considered private. If you're developing a program you know that you actually have to pay attention to personal privacy rights in terms of it's a web application that you're doing, and you're the software engineer, you created the application, it's out there, and then it's exposing people's social security numbers. But believe it or not, you can actually be held liable, responsible for exposing private information to the public, when in fact it shouldn't have been. You're not allowed to expose private information. Increasing amount of public information that's available on the internet. If you think about it, all of those applications to do background checks, lookups, all that stuff out there, very high, kind of sitting on the line of legal versus illegal versus what are we violating. And so what ends up happening is the source of that information, it ends up going under scrutiny in terms of where it came from. Reverse phone lookup techniques, campaign contributions, housing prices. This is just an example of some of the personal information that can't be exposed on the internet. Driver's license information, some photographs actually. In fact, this is all of the issues that you probably have been hearing about within the last year or so with Facebook. You know, privacy rights associated with uploaded pictures. And if you I haven't heard about this yet. They're doing data mining on pictures, on image translation. So they can pretty much map a person where they've been, who they're friends with, what they look like, what their trends are, what they're wearing by pictures. And because we're all being data mined on the internet. So a lot of people don't like that. They don't want other things to be using the data that they're putting up there. Also, you know, relationships with other people, with other companies, stuff like that. As people are kind of thinking, well, maybe we need some more privacy with that. Unfortunately, as soon as you put something out there, it's out there for good. Even if you delete it, it's still out there. So don't ever put anything out there. Well, unless you want it to be public knowledge, don't put anything on the internet. Privacy in email, long, controversial kind of thing. Now it's there's no expectation of privacy anymore in the U.S. So. In the old days, companies, you wrote an email program, you were running the software, you were doing something that was exposing personal email correspondences with people that weren't part of the conversation. You know, you were tapping in your data mining emails, and people were going, what? You can't do that. It's like, nah, you can, actually. Email is property of the company, which makes it also kind of goes into, not on the slide, but the concept of fair use, which is how companies get software, you know, rights to whatever it is you're doing on your computer. You write, let's say, for example, talking about copyright. Good question, actually. To answer your question earlier, you write something, it's a Microsoft Word document. Let's say you're writing a report on some findings and it's stored on the company computer. Who owns it? The company, because it's on the company computer and you did it on company time. Is it copyrightable? Nope. Is it owned by the company? The company can actually copyright it for you, actually. In fact, they own it. Which means if you write an email message, send it out, it's the company's property. So I don't know why people use company computers for personal information. And technically, it belongs to the company. So let's say you invented something and you left the company to go start your business idea. The company owns your invention. You invented it, you wrote the email, you wrote out the Word file while you were working for the company on company time. So long story short, get a notebook computer, do it at home. Don't invent something on company time. So otherwise you're going to end up in trouble. All right, legal email is like personal postal mail. There's an expectation of privacy in transit. Mail loses its special protection status once it leaves the letter carrier's grasp. So actually in the United States there is an expectation of privacy for the U.S. Postal Service. It doesn't actually apply towards non-U.S. Postal Service carriers. If you send a personal letter to your friend and you use the U.S. mail system and you put a U.S. mail stamp on it, it goes through the U.S. mail system. It's against the law for anybody else to open up that letter and read it. And you can actually prosecute them on a federal court level. However, if you send it via FedEx, UPS, Messenger, airmail, bird, whatever. No protection at all. Email, no protection at all. That's where those email rights actually come from, the fact that unless it's certified U.S. Postal Service, there's no protection. It leaves the arena. So for email expectation of privacy while signal transfers over the internet, there's some internet. If you get into networking issues and you start looking at that, that brings up another whole big old bag of problems. What about, in the old days, these are these butt sets you hook up to telephone lines. You can listen to telephone conversation called eavesdropping. And there's major laws against phone wiretapping, eavesdropping, and so. What about internet traffic? What about stealing packets and surfing the internet and listening to other people's stuff? Well, there's actually, believe it or not, no laws against it yet, but that's one of the things. That's one of the interesting parts about this whole legal system that's actually coming to light in the last couple of years. Actually, is how do we regulate it? How do you say something's right or wrong? Because here's the problem with technology and software engineering in general. If it's cutting edge, if no one's doing it yet, and if it actually does something interesting, it's a sellable product. It's something you want to invent and use. However, a lot of that stuff crosses the line of different morals, different values, just because you can data mine the internet and find out who's eating at which restaurant and what kind of food people like, is it legal to use that information? Which kind of poses a lot of issues. So that's why I find actual intellectual property kind of an interesting subject matter, because there's nothing. It's so brand new, actually. And then you think the year 2011, we'd have all this stuff figured out. We haven't even started figuring any of this stuff out yet. So, all right, back to wrap up on the privacy issues. Email loses its protection status at the mail server, whether you've read it or not. Actually, there's no protection. Long story short, if you send an email message, you're putting it out on Facebook. You're posting it for everybody to read, essentially, because people will be reading it. Is there privacy in the workplace? What about tests for employees? Do you have a reasonable expectation of privacy when you're sitting at your desk? Work-related material on the business machines is definitely not private. Some organizations, most universities treat private email or business messages as private. But this isn't the law, actually. It's the company policy. The law actually doesn't exist. So essentially, you're opening and you're exposing yourself to problems. Never send anything by email that would not be prepared for your employer to see. In fact, there's nice little network applications. In fact, this is a growing area, software engineering. Network monitoring. What are people downloading? What are people sending? Who hates this person? Who likes that person? What's going on? Everyone's so nosy about everybody else's business. Web surfing applications that go out and collect information about everybody on the corporate network and stuff like that. There's great applications in that. So as software engineers, you may come across people's private information. If you don't keep it private, you might actually end up in court. You have to keep it private. If in doubt, consult a supervisor or permission, essentially, because what ends up happening is you're looking at a program, you're fixing a problem on a program. Happens a lot in banking applications, actually. You're in there and you're exposed to information. It's kind of like what criminals do. In fact, for a long time, I never quite figured out why. They used to run telephone sales through prisons. They had, in the U.S., in a state penitentiary, they had prisoners answering the phone and taking credit card numbers and processing orders for customers. Well, yeah, they're going to write down the telephone. They're going to write down the person's name, their credit card number, all the information. But then they're going to go ahead and sell it to somebody else. So they've gotten information obtained legally, used illegally. So they closed that down. No more of that stuff going on. But that actually, I can't believe someone actually did that. I can't believe a company actually did that, which is kind of amazing. Contracted work out their prisoners with personal information over the phone that was misused. And it happens, believe it or not, all the time still. In fact, when people are traveling, you actually have a higher risk. Because you're not at home checking your account balance. So you go to Hawaii for the weekend or for the week, and you go and you rent a surfboard or something, and you use your credit card. You're out there surfing. They know where you are. So meanwhile, back at the office where you rented the surfboard from, they're on the phone or on the internet using your credit card all over the world, making purchases on your information. It happens. It still happens today, actually. So how do you get around it? That's tough. You take chances, I guess, and you keep monitoring. And there's a bunch of new software techniques, actually, that send you instant messages every time your card is being used. And like Chase does that, actually. Sends you a text message, you know, and, oh, yeah, your card was just used. Wait a minute, I'm out here surfing. How come my card was just used? You know, so you can kind of keep tabs on it. All right, moving right along to wrap this up with business email. Electronic Communication Privacy Act 1986 says all business communication belongs to that business. So if you remember anything, just remember that business owns everything. You don't own anything. Deleting email can be ruled intentionally destroying company records, actually. This is what everybody does when they get fired. Well, you guys probably haven't, hopefully you have never experienced this, but as soon as you get fired, all of a sudden rage takes over and you start deleting everything on your computer. So it's just a natural reaction for American employees. If you've ever been fired, don't do that. Because what ends up happening is, well, they're going to restore it anyway because it's all backed up. But you're destroying company records, company property. You can be held responsible for anything that you deleted that you shouldn't have deleted, you know, because you don't want them to know all the hard work you've been doing, so you delete it all. So an archive is worthless if it cannot be indexed effectively, so whatever. All right, free speech. Oh, this is another interesting part that kind of crosses over into software engineering as well. The United States First Amendment, long time ago, protects aspects of free speech, including news reports, religious expressions, things of that nature, trade secrets, state secrets, defamation, racial hatred, all sorts of different little categories in there. So now we have government, people that are working for the military who are selling secrets. Some of them are publishing it on blogs. Software that's created to facilitate communication of information from point A to point B ends up falling under Free Speech Act and whether or not it violates free speech and freedom of speech. And then you end up in court because you created a blog for which so-and-so logged on to and so-and-so posted stuff about what the U.S. military is doing over there in Iraq or something. And I was like, oh, wow, great, you know. Now you're held liable because somebody used their freedom of speech, which they violated some trade secret, or they violated some contract they signed when they joined the military that said they weren't going to tell the American people what's going on over there and wherever they're at, kind of thing. So you're not actually allowed to say stuff when you're like, if you've been following the military kind of problems that they've had. People are all of a sudden saying everything about anything without thinking about consequences that might be associated with it, you know. Then they become traitors. They're bad people now because they're not, you know, they're giving away information they shouldn't be giving away in the first place. Anyway, so in the U.S., some aspects, obscenities are governed by state laws, different among different states, which means you can't put stuff in software programs, websites, applications that offends other people as well. So you can't create a racially discriminatory program that puts out messages, even things like error messages and stuff. You know, you can't like put hatred stuff in there, you know. So you bought Microsoft Windows and Microsoft Windows comes up and says, hey, you white person, you're stupid. Why did you do that, you white person, or something like that? I don't know. Then, you know, you might have a lawsuit against you, actually, if you actually document that. That might be violating freedom of speech. So laws in other countries may also be different. Criticism of the government, issues associated with it. So special circumstances, internet service providers. So internet service providers that transmit and store intellectual property that they don't own is an exception because you're providing it. So if you think about the concept, if you held internet service providers liable for everything that was going through their server, and you were sending bad messages about so-and-so through there, exercising your right to freedom of speech or whatever, we're not going to hold you responsible for it if you're the provider. Special complex legal framework protects them. If you run such a service, you need a knowledgeable lawyer, because what ends up happening is you have all of your clients who are signing up for your service sign something. Same thing you signed when you signed up, hopefully, for Facebook a long time ago. Depending upon when you signed up, you may not have signed the current agreement, which means you may have to sign over and over again more agreements that come through. You get this in software when you install updates. Because all of a sudden, if there's a new feature that's added, a new instant messaging feature of the program, all of a sudden there's going to be a new thing for you to sign, to agree to, that says, oh, and I won't send out I'm not going to hold the company responsible for bad messages that people send me or something like that. E-commerce also presents another exception to it. E-commerce operates across jurisdictional boundaries, across states, across countries. So freedom of speech laws are a little bit different among that. Data is subject to various different laws of privacy, security, and stuff like that. So if you run such a service, you also need to consult with an attorney. Service on the internet, software. It doesn't matter if it's on the internet or not on the internet is the point, actually. Anything that actually works with speech, freedom of expression, it needs consultation. Otherwise, you might end up in a problem as well. So now we have personnel in terms of participants in business law. Every state has strict and complex laws about recruitment, hiring, terminating, firing, job conditions. This also ends up being part of the legal system in terms of, can they fire you as a contractor? Can they hold you liable for something? As a personnel, as a contractor, as a human being, and part of HR, you have rights actually in this country. Every employee has more rights than non-employees because you're working under somebody else's guidance. So many employers run short courses for their supervisors, and they train the management on acceptable use of this, acceptable use of that, programs, applications, and things of that nature. You have a now consultant expert, essentially. And then essentially the employment contract may also restrict your next job. This is an interesting thing for software engineers. A company that hires you can tell you where you can't work for your next job, which is interesting because most people aren't even aware of it. So sometimes when you join the company, you're a software engineer and you're working at Apple and you're working on iTunes, they might not necessarily want you to work in another company that sells another product like iTunes or like whatever it is that you're exposed to. In your contract, they can say, non-compete agreement that says once you get done, you can't work for another company that sells iPods or MP3 players or iTunes for 2 years or for 1 year. And if you haven't read your contract, you may not even be aware of it. But essentially, as a software, this happens a lot because people don't want their trade secrets stolen. They don't want you because you have expertise, because you have proven yourself on the job and you've done a good job for them. They don't want you to do a good job for somebody else who they're competing with, which is technically, if I was a software company, I'd do the same thing. I don't want you working for somebody else because you're gonna ruin my competition. I've got the market right now. So your employment contract can restrict it, not working for companies of the competitors. It has to be within reason, and it has to be explicitly spelled out. It can't be, you can't work for another software company. Well, if you're a software engineer, that's what you're going to do. You're going to work for another software company. So it has to be a little bit more scoped, a little bit more specific than that. Trade secret information, non-disclosure agreements are normally something that you'd sign. Contamination, knowledge of trade secrets may prevent you from working on similar projects than others. So you don't contaminate your trade secret with something else. Similar projects for others might actually be an issue because even though you don't give it away, you know how something is done correctly. So you might actually, contaminate the working environment where you went to next, which might actually be an issue. So ask before you accept a job, essentially. As a contractor, I don't know if most of you probably won't actually run into that situation. Generally, you get it when you're working in a particular industry. If you're just doing generic kind of contract work, no problem. If you're working for like banking companies, financial companies who are working on proprietary systems for online this, online that, they don't want you going anywhere else. And they're not going to pay you forever. Eventually, they're going to let you go. And then what ends up happening is whatever is in your contract is what you agreed to. So you'll have to work for a different type of company in the future on your next job, maybe. So read the employment contract before you sign it. Some practical advice. It's often useful to read the text of the law, although it may not necessarily be something that you can understand easily. It's a little complicated at times. You can find good sources over the internet. But don't try to interpret the law yourself, as the underlying statement says, because usually what you read is something that wasn't intended, or that perhaps could be read in a lot of different ways. In fact, if you read software license agreements, they're negative. They're terrible. they're just like, you know, you don't have any rights at all. You might as well just delete the software now and not even install it. I mean, if you actually read that stuff, it's pretty bad, actually. I mean, but you don't read it. You know, I mean, if you read it, you actually listen to it. It's, in fact, there's like an old joke, like, you know, in the old days, customer support, technical support line, you know, they answer the phone. And someone's got a question about a line in the software license agreement. They don't understand what, you know, you cannot install this on blah, 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 whatever. And it goes back and forth, and the bottom line is nobody understands it, not even the person on the phone. So it's like incomprehensible. So beware of the law, but don't pretend to be a lawyer. Use professional help. In fact, there's companies out there, consulting companies, that consult only with software engineering companies, that write your software license agreement, that look at your source code, do a desk check of it, see if you're using something else, see if you needed to get a license for this or for that utility, to see if, you know, what are you running with, what are you doing. So you can actually get pre-screened ahead of time so that when you actually do release the software, it's something that you're not going to actually have a problem with, hopefully. And there's a lot of business, actually. There's a lot of good business in consulting, legal consultants for software engineering companies, because they seem to present a lot of issues, actually. So anyway, contracts, license, unless you're very exchanged by letters, trouble, personnel issues. When in doubt, ask for help, essentially. So that is everything you ever wanted to know about the legal system as it applies towards software engineering. I went over a lot of different concepts, brushed on everything, didn't give you a lot of details, so I highly recommend, if you have an interest in, as you have an interest in copyright material, go online. There's a wealth of information online. The problem, what you're going to end up with, is you're going to find many different interpretations. You're going to find one website that says, you know, put it in a stamped envelope, mail it to yourself. You're going to find another one that just says, sign it in pen. You're another one that's just going to say something else. Because there's a lot of controversy, there's a lot of miscommunication, there's a lot of things in it. This is kind of a growing area as it applies towards software engineering. It's not a mature field in the law, something that's just under development now, and every year poses brand new issues. So there may not necessarily be an answer, actually, to any particular complex software engineering type of scenario that you might run into. So I will leave you with that, actually. Thanks for being quiet today. Actually, I noticed either that, or I was talking loud enough so you could hear me, or you guys were being very respectful. So thank you. Make sure to sign the roster, and I'll see you next time.